Hello, good evening, welcome to our front. My name is Raymond Akwa. Yesterday, some action started from government. The Attorney General of the Republic of Ghana dragged 4 people, including the man who set up the bank, Capital Bank, which is now, of course, we know, has actually been taken over and has been merged with an institution called CBG. That particular action was because government believes that William Atu-Essien and 3 others did steal and also engage in money laundering and other offenses that are outside the banking and other financial institutions act in this particular case. Today we'll be asking whether this is the expected move by the Central Bank and the Republic of Ghana, represented by this government, to do the things required of it as has been demanded by many. The minority in Ghana's parliament will be sharing some very interesting thoughts on this particular matter too. Also, we will get you a lawyer's independent assessment of what the charge sheet looks like and why we are heading this particular path after this break. You welcome back. This is UPfront. My name is Raymond Akwa. Today, you've heard from government. You've heard the move they are making in court on this particular issue to do with the mess in the financial sector government sought to clear. You know that some banks collapsed in the couple of years that we have seen happen, and government took steps to try and clean up the system. One of the things that was demanded by many is that we need to see you prosecute people who were responsible criminally for their actions. Government yesterday commenced that particular action by dragging the founder of the institution called Capital Bank, which is no longer in existence as we have it today. Of course, it's in receivership as we have it. That particular institution was dragged to court. As it's being dragged to court, we understand that some other actions are following. And we know that William Atu-Essien, who recently has been speaking anyway, who is actually the man who set up that institution called Capital Bank from its beginning to the time we found it and the actions that follow from there. Now, we also know that 3 others, including former CEO and also one MC Management Services Limited CEO called Dr. Tetenete, and what shocked many was the involvement of the woman who's been leading railroad cables for a very long time. That is in the person of Kate Corte Papafio. What is this the silver bullet to show you that really we are doing real action on the ground? Today, 2 people will help me understand this better. First, Elik Magbemava is a lawyer. He's a lawyer who understands finance too. He's a lawyer who understands the law when it comes to some of these issues. He will seek to put into proper perspective the charges labeled against the people. And also, one man who's been demanding action from the Bank of Ghana and also from government, who's been opposing the actions and saying that we could have used an alternative, far more improved method in doing what we ought to do in the banking sector, is the Member of Parliament and also the Member of Parliament's Finance Committee, the Honorable Isaac Adongo. You welcome, Honorable.
Thank you.
I hope you are doing well this evening.
By the Almighty God.
And Ellie, I hope you are doing well too.
Yes, by the
How
grace
is the
of God.
firm doing?
It's doing great.
Now, Honorable, when you heard that government has dragged these people to court, you obviously were impressed that government is doing something about it, weren't you?
To the contrary, I was rather very disappointed. Very disappointed because what I saw was a day of shame for Ghana. The banking sector issues, particularly to do with the taking of Capital Bank, was very chronicled. Mm-hmm. There was a clear agenda to whitewash the people of Ghana into believing a certain narrative. That narrative was that they had sent Boulder's advisors to do some investigations.
And they put out a report.
Yeah, put out a report. The report was consciously serialized in order to get the people of Ghana into a certain mode to accept the collapse of the bank. One of the issues that we were made to believe was that William Atu-Essien, and I want to emphasize that I don't speak for William Atu-Essien. I am not here to defend William Atu-Essien. I'm here to look at the bigger national interests. That shareholders, including William Atu-Essien and others, had fraudulently obtained the license of the bank. And to the extent that even the capital that was used to take the bank was manipulated. And that was criminal, and that was the reason the license was taken. The second argument was that 610 million Ghana cedis of liquidity support that was given by Bank of Ghana to Capital Bank was shared among the board of directors, including Dr. Pastor Otabel. And therefore, these were enough grounds for the license to be revoked and for Capital Bank to be collapsed. We were of the view that even if this were true, they were not basis to collapse a bank. Because you see, the bank is a separate legal entity, separate and distinct from the owners. So the misconduct or the violation of fiduciary relationship between the directors and the bank cannot adversely affect the life of the bank. So if directors have shared 610 million, which belongs to the bank, who is the victim here? Is the bank. So who do you kill? The bank? That is a victim. Two, if they fraudulently procured the license, it's equivalent to saying that a child is born out of wedlock, and therefore that child must be killed. Or somebody sleeps with somebody's wife and produces a child. Because that child is an illegitimate, we have to kill that child. It doesn't happen like that.
No, but there's a general principle in law that says fraud vitiates all.
You know, fraud does not, which fraud vitiates what? I am saying that fraud that leads to a human being, especially when there are processes that can lead to you finding it difficult to approve the same allegations. Now, you now end up saying that all these things that you said did not appear in the writ. All these things that you said and prepared our minds for were not on the charges. What are the charges? That one of the directors stole money from the bank. So when you steal money from a bank, we kill the bank. When you steal money from a bank, we kill the bank.
But we're made to know that the bank was in an office of incapable of standing on its feet, mindful of its financial status.
I am saying that they claim that these were the claims that they made. Today we are not in court for the very reasons that they provided for collapse of the bank. We are in court over stealing. I don't even want to go into the merit of whether or not the man's this stealing thing makes sense or not. But I'm saying, so an accountant of Joy FM or Joy TV steals money, or the owner of the company steals money, so you collapse the company. So the question, the substantive question is, does this answer the question whether or not, on the basis of what you are now prosecuting, the bank ought to live or ought to die? And that is the biggest shame of the moment. That after all this hula baloo, it was much ado about nothing. And that this was basically, principally, greed.
On whose side?
Greed on the part of the people who wanted to acquire this bank when they were in opposition and couldn't get it.
But they have denied that.
They have denied, but there are records.
Issued a statement categorically.
I also issued a statement showing them the letter dated 12 May 2015, signed by Kelly Gejepo.
That they will acquire shares.
To acquire shares means what? We want to invest in the bank. Acquiring shares means what?
Yes, but investments is what.
No, acquiring shares means what?
That they will be interested in the bank.
If you want to acquire shares, how can you own a bank without buying shares? No. You own a bank, you take a bank by buying shares.
But at that point in time, it is up to the people who own the bank to see that we are giving the shares in the first place.
So the guy says, I'm not giving you. Yes. And now you have an opportunity to deal with him. So you take his bank. That is what I'm making the point. That statement itself by their lawyers was the biggest scam, because there are records and letters to show that you truly approached the man to take the bank. So why were you asking your lawyers to lie to the people of Ghana? That you needed lawyers to lie to us when you have actually signed. And what was annoying was that one of the people who signed the letter, Kali Gejepo, was one of those who instructed their lawyers to throw dust into our eyes. And I'm saying that on the score of what we saw yesterday, it was Ghana's day of shame. If this is what we are now going to use to justify why we took a bank, that's stealing. Do you know how much has been stolen from banks in Ghana? Look, I doubt whether there's any bank in Ghana that will survive if we were to go by who has stolen. Okay, look at the Banks Special Deposit Taking Institutions Act. Okay? Look at Act 930. And show me where one of the grounds for revoking a license is that a bank's money has been stolen.
But the revocation of the license was based on specific issues detailed in the Bank of Ghana's release. And you saw that release for every single, the quoted part of the act in this case.
For everything that they put there, I can give you thousands of them for banks that exist. And I'm happy a lawyer is sitting here. The Bank of Ghana, the Banks and Special Deposit Taking Institution Act 930 says that before you take the license of a bank, you need to write to the directors and shareholders 1 month in advance for them to respond and give specific reasons. When they respond and you disagree and you take the bank, you go to arbitration. Here, banks were taken on air. Do you get what I'm saying? So even granted that all the excuses that you are giving is true, natural justice and due process requires that you follow the law. And the law says, give me 1 month notice. And give me reasons why you are taking the bank. Now, if these people go to court today and they say that on the basis of natural justice and fairness, I am not disputing that you have the power to revoke a license, but you have not followed the due process. And therefore, my bank was illegally taken. Can you imagine the level of judgment debts that confront this country?
But we know that Atuesi are in court already. It's not.
It is not only Atuesi.
Yes,
I know of Big Bank where they just arrived, they were giving you the letter and taking the bank. Do you get what I'm saying? UT Bank, the owner says, I heard it on radio. Unibank, the law is quite clear. If you want to take a bank under administration, and you give the administrator 4 months, within 3 months, the administrator is supposed to produce an interim report, and that was what KPMG produced. Okay? And when the interim report is produced, at the end of the administration, you are supposed to produce a special report with clear recommendations of what should be happening to the bank. And when you are producing that special report, you should also be producing an inventory of assets of the bank. What did we see? An interim report that was laden with disclaimers. The auditor KPMG says, this report, I did not validate these numbers. You cannot use this report to take any action. And if you use this report, you are on your own. Despite the fact that the law says you must continue to get a special report with inventory of assets that gives you recommendations to act, they took it on the basis of an interim report that was disclaimed. So
I'll come back to you.
We are facing a mountain of judgment debts in future. And this cannot be wished away by any fraudulent misconduct of a so-called lawsuit that just scratches the surface and doesn't deal with the substantive matters of why a bank collapsed because somebody now is alleged to have stolen money from that bank.
I will get your point, and I'm sure we'll deal with the details of what you just raised preliminarily. And you heard the Honorable Isaac, I don't go on that. Yes. Lawyer, let me understand this. The reasons have been given. There's one on stealing, which is contrary to law provided in the Criminal Offences Act. Yes. There's one on money laundering, which is also contrary to law provided in the Money Laundering Act in this particular state.
Yes.
What's the big deal?
Well, the big deal is that for such a voluminous act, that's sought to reform the banking sector, we don't have, offenses that seeks to punish, people that flout the provisions of the act. So you see the Attorney General now running to the Criminal Offences Act to find crimes to tag or to attach to these people who have been charged. I think it's not a natural, move, because of what Honorable is saying, the Boulders report and the allegations that were in the Boulders report. One would have thought that we would have, specific crimes coming out of, these reports and for which these guys will be prosecuted, But to charge them for stealing in a case of loans where approvals were given by board of directors and all that, is very strange and very difficult to understand.
I'm struggling to get where your difficulty is.
Yes.
So government says, I received reports.
Yes.
The Bank of Ghana revoked the licenses of Capital and UT first round. We saw the first. That was the first move and actually asked for GCB takeover, and that's the statement that they issued in there. The reasoning for that is what we're told in the Boulders report. Then later on, they said that Ghana had done a lot of engagement with them. And they spent towards some 620 million, what happened to the money and all of the difficulties that they went through. Indeed, when it was revoking the licenses, it stated categorically the sections of the Bank and Other Financial Institutions Act that actually, the Act 930, based on which was acting in this particular case. Are you saying that you would have expected them going to court to use the same act?
Yes, but no, you know, first of all, let me clarify this issue. The timelines we are dealing with do not apply to the act as we have it now. They happened before the act was promulgated by Parliament.
I don't understand what you're saying.
The
Act 930 was
act,
somewhere in September 2016.
Yes,
it was actually
but we are talking about things that happened in 2015, November 2015. Therefore, at the time they were happening, the 2016 Act was not in force.
The law had not come into force.
Yes, and the Constitution provides in Article 107 thereabout, or 106, that there should not be any retroactivity. So these crimes that have happened before the Act cannot be prosecuted, whether in the civil proceedings or criminal proceedings, cannot be prosecuted under the 2016 Act. So,
but that's why government did not use the 2016 Act. It's not clear.
Yes, but at the time there was a banking law in force, the 2004 Act, and you know, even that, there are still no provisions to criminalize these acts they are talking about. So therefore, anything that is described in the Boulders report is not a crime. It cannot be a crime. That is why they have now shifted to the Criminal Offences Act and charge people for stealing, and also the Anti-Money Laundering Act. And I'm saying that these are not natural, what should I say? Yes, a sequence of things. And they are going to really, really find it difficult to prove, you know, the elements of stealing.
I'm sure they are going to court, and that matter will come up in court.
Yes.
But what you're saying is that what mostly happens is when these reports are developed, the reports pinpoint to where there's been some wrongdoing. And based on those wrongdoings, you proceed to now charge people and actually get to court. So you cannot have reports on one law, and yet what you're taking to them to court on is on a different law. Is that what you're saying? You can. But what I'm saying is that the charge of stealing will be difficult to prove on the basis of what was contained in the report and what happened. You describe these guys as taking loans from, illegal loans from a company. And how do you then turn around to charge them with stealing? Because loans pass through processes. And you know, they put papers before the board, everybody knew what was going on, and these monies were given to them. So why do you say they stole? You know, stealing is done without people's knowledge and with some form of dishonesty. There is no transparency. People don't know when you are stealing. So at this point, where is the dishonesty? But I don't know the evidence that the government has in this case.
We all know. It's the Boulders report. What evidence again?
You don't think that it has something beyond that? You don't think it has anything beyond that?
No, that is what they've given us to work with. So if there is something more, they should let us know. That's one issue I have with how these matters are being handled. You know, there should be more information for people to be able to
Yes, I need to understand that, because what you explained to me sounded to people that, well, we thought action was being taken, but this does not look like action that may lead anywhere.
It won't lead anywhere. It wouldn't.
You are very bold in that, even though you've not seen what government is putting before the court in this case.
I'm saying that looking at the allegations,
the charge sheet
you see, I'm not saying something may not have gone wrong.
Okay.
Something have gone wrong, but technically, the way the government is approaching this issue will not bring any results. And we've seen time and again many criminal prosecutions in this country ending nowhere. And it's very important that each time we do these things, we look at the facts and not just force, you know, the issue. Because it seems to me that this charge has been leveled, this charge sheet has been filed only because of the interview the young man gave, Michael Essien gave, you know, to Paul Adomotri. Yes.
Why
the coincidence is so clear.
But we were promised that when the legal application is over, government was going to actually take them to court, and this was prior to that interview.
If I can,
yes,
yes.
See, whether you go to court or not is not an issue. Anybody can go to court. I can't have a saying that Udi can go court and I won't be. The fact that you take the lead to court doesn't mean that
you've won the case.
You've won the case. And you see, in most instances, what they do is they list so many charges.
26 of them.
I remember one of them happened recently. They had opening about 27. Then somebody said, "Oh, 27 kwade ba kubenyano." You know, that kind of attitude is where we are. But Chief, still, this man, was he an executive director? Was he having an office of profit in the company every day, sitting there and working every day? Was he the accountant or a cashier? Said that people came and made deposit and he miraculously put the money in his pocket and left. Yes. Or that he took the checkbook and wrote check and took money Nicodemously and left. Is that what that is what we call stealing? Okay. But in this case, if I follow processes and you feel that the processes were circumvented somewhere along the line, somebody might have connived with me within the bank, an officer in the bank might have aided and abetted me. In that case, you are talking about either fraud or conflict of interest. But that's in that case, when I'm going, that man who played a role with me to steal is in tow. Okay, but you don't go to a bank and tell a non-executive director that he has stolen money. So it's not only Atuesian, that's actually before it's being charged. Whoever is put there. The CEO of the bank at the time that the incident happened, who is Fitzgerald Odonko, is also being charged in this case. So what did he do? He just took money into his pocket and left the bank. No, what is being said here is that he, Fitzgerald Odonko, between October and November 2015, in Accra, in the Greater Accra region, abetted William Atuesian and Tetenate to dishonestly appropriate the sum of 100 million, which is the property of the... They can write all the English. Yeah, but stealing is also being pointed out here. My biggest problem is this. Yes. So, is that why you collapse the bank? Is that why employees are sitting at home? Is that why you and I spent 2.3 billion Ghana cedis to GCB Bank? So, what law says that if a director or shareholder steals from a bank, you collapse the bank? Show me that law. Because all that you have said does not lead to why a bank must be collapsed. Why you and I must cough up 2.3 billion. It doesn't lead us to that. It does not tell us why people are at home. It does not answer the question whether or not any reasonable person in a position of trust at the Bank of Ghana and at the Ministry of Finance would have taken the decision that was taken. Fine. You can pursue Atuesian and imprison him. It doesn't answer the question whether or not one of the conditions for collapsing a bank is that a shareholder stole money from that bank. Otherwise, we had this Ghanaian in the UK, something Adoboli or whatever. You remember? Yes. He stole how much? £2 billion from Barclays Bank. Is Barclays Bank dead? But do you know the number of people who are stealing every day from the banks? But there's the reason why the bank's license was revoked was stated by the Bank of Ghana. Is that the reason they are in court? So how come we are in court now? Yes. None of the reasons that were listed is the reasons for which somebody must go to jail. The first reason they gave was that UT and Capital Bank were deeply insolvent. That's the point they made in there. Of course, if they are insolvent, and proceeded to say that, of course, what they also said was that their liabilities exceeded their assets and putting them in a position not to be able to meet their obligations and when they fell due. They also mentioned that despite repeated agreements between the Bank of Ghana and UT and Capital Bank to implement action plan to address these significant shortfalls, the owners and managers of UT and Capital Bank were unable to increase the capital of the banks to address the insolvency. So the main reason for the revocation of the license was the insolvency. So, and that's been explained. And the holders went there and they came and gave a different reason to us. Now, let me ask you a very basic question. We spent 2.3 billion to collapse the banks. Those two banks. Let's say this bank about 1.2 billion to collapse it. Okay? There's a savings and credit union in Canada called Pace Savings and Credit Union. It's worth $3 billion. When it started having financial challenges, it was not closed down. Okay? The Bank of Canada intervened, dealt with the liquidity challenges or whatever challenges they were, and today, not even a single job was lost. Today, that bank is still alive. In China, 2 national banks have been rescued in the last 5 months.
Okay.
One of them, a regional bank worth $90 billion. When we say a regional bank, a bank that just operates in Greater Accra, $90 billion. It wasn't closed down. So, if you have a governor who does not understand the wider systemic implication of collapsing a bank, it wasn't here, this same, your office here at Newsfile. I recommended that instead of waiting to put almost 13 billion down the drain, we set up an equity fund. Deal with the banks that are struggling, negotiate with shareholders behind the scenes, value these banks, and pump those monies in as equity. Run the banks with an exit strategy of say 3 to 4, 5 years. And when the banks are on their feet, you sell them back to their owners and take your money away, and the state will not spend and lose a penny. Today, you are now saying that when a bank is in insolvency, the only solution available is to collapse it and throw money down the drain and ask people to go and sit at home. In a country where we struggle to create NAPCO jobs, you collapse well-paid jobs and you struggle to pay allowances for NAPCO. And you say what? This is a solution, and this is the governor who is sitting there.
The Bank of Ghana responded to whether there was an alternative route to this matter.
They don't have to respond, please.
They put it out
they
carefully.
Can't, see,
but
they
it's
respond
important.
Make sense.
No, take your time. It's honorable. Oh. Let me tell you what the Bank of Ghana said.
Everybody heard it.
You know that, yeah. Right?
And
but you should be convinced that that was a very reasonable response. Yes.
Today, didn't they come to see here? The deputy governor comes to sit here and tell you that she saw the money for GAT. She came and sat here and said she saw the money for GAT. Today, do you know what's happening at GAT? It is the biggest scandal waiting to happen.
Sorry, GAT is the Ghana
Amalgamated Trust, which was supposed to have taken 2 billion, guarantee from state to go and borrow, which I took them to court. Today, do you know what's happening? Suddenly.
But if the matter is before court.
I am saying suddenly. I'm not talking about that. Suddenly. When the shareholders recently, the Bank of Ghana governor recently said that the monies have come. Do you know what is happening? Somebody is trying to wash 160 million euros from Europe. And the monies that are coming, it is no longer GAT, but the company confronted, that is being fronted by a senior member of Data Bank. It's now the one wanting to give 130 million to a Med Bank and take 44% of that bank, Ghanaian bank.
I've seen no evidence to corroborate this claim.
Don't worry.
I've seen no evidence.
I am saying that what is going to happen in the next couple of weeks will blow your mind.
Okay, so until then when we can all interrogate.
When we start getting to know what kind of Orata truly is,
when we can
all people who wear white shirts and quote the Bible.
Forgive me. I mean, but you should understand that you have not presented any evidence in this matter.
I am telling you that
but when you bring the evidence to the table,
and the what have you in this country.
Honorable, can we stay on this course so that when you bring evidence, I'll deal with GAT in and of itself?
GAT itself.
Yes.
We know it's a scam. Don't we?
No, sorry. I mean, see. You have made
so many money from GAT.
You have made so many declarative statements on this particular point. Yes. I'm saying you've not shown me any evidence to support it.
Okay.
Until you present the evidence to me, let's stay with what I'm talking about now.
But what we are talking about here is that there is no reason any of the banks should have gone down.
No, hold on. The question was asked whether or not there was an alternative or a possible solution to closing down these banks. Yes. And the governor of the Bank of Ghana stated categorically that the Bank of Ghana made efforts to help these banks recover via private alternatives. However, the banks were unable to develop an acceptable plan. And the proceeded said after exhausting all other alternatives, the BOG has chosen or chose then to resolve them via the least costly method of a purchase and assumption transaction to protect the depositors in this particular case. Okay. You should be clear in your mind on this matter.
I am happy that you are bringing, let me tell you, Heritage Bank was approached by the Bank of Ghana to merge with UNB. Listen to me carefully. Heritage Bank proceeded on the basis of that request to appoint Pricewaterhouse to do due diligence on UMB, Universal Merchant Bank. It turned out that related party transactions that had to be impaired will push UMB into negative net worth. The owner of Heritage Bank said, I cannot merge good assets with toxic assets. 3 weeks later, they had a reason to take his license. The reason was that he was in court. He's not been proven guilty, even though our laws are quite clear Because he is in court, his license was revoked. Listen to me. So, if he had agreed to merge Heritage Bank with UMB, what would have happened? Would we have been hearing this cock and bull story about Heritage Bank? Okay, Sovereign Bank, your reason is that he took a loan to set up the bank, which is wrong. That's your view. Why will you collapse such a bank? The punishment for using inappropriate funds to set up a bank is to collect the bank from the bank person and run the bank and not to collapse it. So, in their view, the only cost-effective manner was the one that satisfied their ulterior motive of killing their competitors for Kenoforiata. And for you and I to now cough billions of Ghana cedis that we can't even find just to satisfy this ego.
Monies we intend to retrieve, don't we?
Retrieve from who?
But we are actually in court with them to retrieve the money.
How much have they retrieved?
They are the process of retrieving.
When you are in court,
no,
do you
but
know?
it doesn't take a week.
When you are in court, listen, when you are in court, what shows that you are winning the case in court? You say, don't speculate a case in court. And I'm saying that out of total loans of 10 billion that were sitting on these books, the books of these banks, are you suggesting that none of those 10 billion was performing? Why didn't they pick out those that are performing to give to CBG in order to reduce the amount of money the state had to pay to CBG? Why didn't they do that? Why?
Now,
I'm asking you a very basic question.
But I don't represent the Bank of Ghana. I am not the finance minister.
Good. So
I will not participate in the revocation of the license or the decision.
So you should now begin to reorient yourself to understand that this whole exercise was a bogus exercise. And there is no reason why any Ghanaian should forgive Kenoforiata and Akufo-Addo for properly setting up from the onset to take Ghanaian banks. Do you know why? As we speak today, what's happening?
That's a big allegation.
It is a big. I will make that allegation. I will make that allegation. I will make that allegation in front of Kenoforiata and the President of the Republic.
Sorry, but you have not presented any proof to me today that there is also this scheme to do so. To protect protect you from possible liabilities that you might not be able to.
Then don't worry about me. Just simply say that. Just simply tell the public that what I'm saying is my view, and you are protected.
I'm saying that.
I am saying that the agreements that have been signed with some of the Ghanaian banks is tantamount to armed robbery of Ghanaian private banks.
So, what agreement are you talking about?
I am saying that agreements have been signed with the 5 banks.
The ones you receive
for that to come in. They have eliminated NIB. Do you know why they have eliminated NIB? The minister was recently telling everybody that they are going to set up a new national development bank. That is a lie. They have brought consultants.
You are saying that there's an intent, but the intent is a lie.
They have brought consultants today who have been sitting at NIB for the past 4 weeks, preparing a strategic plan to redirect the focus of that bank into a development bank. In the process, the good assets of NIB are being stripped off and taken to the Ministry of Finance, including the Nestle shares that are sitting at NIB and now feeding away toxic debt. Let me explain something to you. One of the biggest problems of NIB is that it has not been able to recapitalize. Because of that, the market doesn't have confidence in NIB and they are taking their money. What the market wants to hear today is that NIB has taken a major step towards recapitalization and the market will come and depositor will stop going there and they will go and put more money there. So if you have shares sitting on the books of NIB that they bought from Nestle, somewhere around 50 to 80 million some years ago, and today it is worth 500 million, what it means is that if they sell those shares, they will make a capital gain of 420 million, which goes to help recapitalization. So what we do is to announce to the public that NIB has sold its Nestle shares in order to raise 500 million towards recapitalization, and they will immediately be confident. You don't do that. You know what you do? You say that people are coming to withdraw their money. So we'll give you 500 million and take the Nestle shares as collateral, so that the people will come and take their money. So when the 500 million is finished, how are you going to pay for the 500 million to get your Nestle shares back? And you say that's what's happening. So those shares are on their way to somebody's house. Okay, but hold on. I mean, again, you've not provided me any proof of this. I'll get to that point, but I want them to challenge me and take me to court on this matter. No, but you can't.
you can't demand challenge on this particular issue.
I know what I'm doing.
But you've not presented the proof.
Okay.
If all of these are basically you're saying without any evidentiary proof before
when I'm coming next time, I should carry my own house here.
No, I'm saying that if it's possible, these are documents. These are documents. Documents that you are in the position to provide.
I understand why Kokubaku has been carrying his bag and it's growing.
Yes, but it's evidential.
I cannot be carrying my bag.
Because if people want to believe you, before people believe you.
When you put me to 8, when I leave here, I'll get it.
Okay, I'll come
and when I get it, it will be disaster.
No problem. But we wanted to see the disastrous evidence presented.
Stealing that is happening, and William should be going with some of these people to court for stealing also.
Okay, hold on. Let me come to you. Let me come to you, lawyer. The question I asked was that the first claim was on stealing. There's also abetment. There's also some form of conspiracy claims that are being made against the people involved in all of this. The explanations are given that, for example, they say that in the particulars of offense for the first one on conspiracy to steal says that William Atuesian, Tetenete, between October and November 2015, agreed to act together with a common purpose to steal the sum of 100 million, which is the property of the bank, Capital Bank, and also when it comes to specifically the stealing one, it says William Atuesian, Tetenete, between October, dishonestly appropriated the sum of 100 million, which is the property of Capital Bank of Canada. It's not clear enough to you.
Oh, you can couch the charge for everybody to understand. But I'm saying that, for you to succeed, you need to prove that, they went and, as you are saying, dishonestly, appropriated the funds. But for a financial institution with protocols and procedures and board of directors, that approves, releases. I don't think that you can say that the board was not aware before those monies were taken.
But the board being aware, does it change anything?
And also, if indeed the board was involved in all these things, why do you selectively, charge some and leave the rest? Because you have a crime of abetment there.
Yes.
So if you are saying
the people that it is believed were involved in the abetment have been quoted here.
Yes, but it's not just some members of the board that helped. All the board members were part of the approval. So, I mean, if you are charging somebody for conspiracy and also abetment, then we must have everybody on the charge sheet.
But even if the board member was not present, would they necessarily have to bear that liability? So if I'm a board member and I was not present during this...
No, at that meeting, yeah, fine. You are not part of what happened. It's a crime, and you have to participate in it. If you didn't participate, you cannot be charged. But what we know is that all the board members were found to have been culpable, and they knew exactly what was going on. So if you want to charge people for abetment, and conspiracy, then everybody must be on the charge sheet. But essentially, the problem with this whole case is that the laws we have, the banking laws we have, do not cater for this problem we have. So therefore, if we want to look at the banking law alone, these people will go scot-free.
And they're not being charged under the banking laws.
Yes, but that's problematic because we have depositors' funds. We have about 620 million CDs that was taken from the Bank of Ghana and given to these guys. And if our banking laws cannot protect these funds, then we are at risk. And till date, the Bank of Ghana has not taken any steps to make sure that in future, 2 years, 3 years down the line, if this same problem happens, our laws will be ready to be able to deal with this. That's the issue.
So you want the act that was put together in 2016 amended?
There should be reforms.
Really?
Yes, there should be reforms.
I thought they were supposed to take care of these
because Section 152, 153, 154 talks about punishment, offenses and punishment. But you read the act and you don't find the offenses in the act. So Article 19 that says that the offense must be defined, it's not satisfied under the Banks and Specialized Institutions Act. So we need to amend that particular law as a matter of urgency and include those offenses that we think has occurred so that we can then now attribute the punishments listed in sections 152, 153, and so forth, and so forth, to those offenses.
So, to the layperson, you're saying that the law that we put together in 2016,
yes,
had specific, what do you call it, punishment for offenses that are not labeled in the act.
Exactly. And it's very strange, you know.
Let me just have, you see,
Yes.
in the case of liquidity, okay, Section 46H of Act 930 is quite clear that the Bank of Ghana, as a lender of last resort, can provide liquidity support to a bank or a financial institution based on certain internal processes. However, that must be collateralized by a more liquid asset, and that liquid asset is defined at 91-day government treasury bills. So there is no security, there is no liquidity that is given for free. As a matter of fact, Bank of Ghana will not lose a penny for the liquidity that was extended because they were fully collateralized. But to make you and I see some people as evil, they behaved as if this was free money given to some people and they shared it. They even told us that Dr. Pastor Otabil was one of those who took some of the monies home. Why is it that today they put that out? Why?
Well, sorry, they said that?
Yes, in the Boldest report.
I didn't see
it. It is there in the Boldest report that he Dr. Otabil, has some monies to pay back. So, what has happened to him? Has he gone to Yoko? Why is he not on his way to court?
But we're told that he and others were invited to Yoko.
I am saying they should show the record of the day he went to court. He went to Yoko. They asked him to write his position from his house to them. He wrote to them. You and I will not have the privilege of writing from the house when Yoko invites you.
Of course, I mean,
exactly. So, but are we different human beings with different laws?
Your point is?
My point is, I cannot see him in the dock with the Chief Justice, whose pastor is Otabil, and paneling a judge to imprison Otabil, and the next day go to stand in front of Otabil to pray for him.
So let's be clear. The Chief Justice is not the one that put the charges.
He is the one who empanels.
But we have not gotten that point.
We are there.
No, take your time. I'm saying that we are at a point where the people have been charged.
And I'm saying
it's unclear to what happens. They'll go to court.
You think we just
but they've not gone to court yet. Sorry, but they've not gone to court.
Where have they filed the charges?
They have filed charges. This is between the Attorney General's office.
Where have they filed the charges?
Except the lawyer saying that what I'm saying is wrong.
Where have they filed the charges?
Have they not filed charges?
No, where have they filed it?
It's not in the court. Yes, in the court.
Who is in the bosom of the court is for whom?
But the people who are the court, sorry, Honorable, some people get it clear. You know that the people who are the court, they don't determine who gets charged.
I am saying
you know that.
I am saying that.
And the Attorney General
I am saying that you and I will not have the privilege of writing to a Yoko. I don't know today. Now, you say, Chorobrem, Yoko. They will come and pick me like a piece of paper.
I'm not disputing
and parade me through the streets. If I'm not even lucky, I will be manhandled.
So you are alleging selectivity in this case?
I'm alleging people ostensibly being above the law.
In this particular case?
I have said something. Can't you hear?
No, I get you. But
do you hear me?
No, my problem is that...
Do you hear me?
What
is your conclusion for what I've said?
What I hear you saying is that people have been treated differently, and that the normal process has been that they go pick up people when they need you at Yoko.
They invite you to Yoko?
Yes, they invite you. People have been invited several times.
They write to Yoko?
Well, of course, I'm sure that in their own arrangement.
How can there be an arrangement? Were you not here when another man said that he had to write from the house? I am saying that the mess we are in is not because of shareholders and directors. Because shareholders and directors, we fight them to recover monies for a company that is alive, which was unfairly treated by the shareholders and directors.
Which is,
but in this case, we are fighting to recover money for a dead bank. Can't you get it? So assuming that you go to court and all of this, the guy wins, and you are wrong, where will the bank be? Will you resurrect the bank? Can't you see it? That it just doesn't make sense. That you collapse a bank, come and give a narrative, and the next day you are going to court is a different song. After we have become used to singing the first song, you want us suddenly to change and sing another song. And why is the bank collapse? Today you are going to court. The things you mentioned. Why is it that you are not sending them to court? You say, oh, this one is stole. So since when did it become a law?
But it's not
that when you steal from a when you steal from a bank, they collapse the bank. That's the point I'm making.
Okay. So you're not
I don't have
concerned
a
about
problem
with the stealing.
if you go to court and
Yes.
you prove that William Atu-Essien stole.
Yes.
Hallelujah. Collect our money for us. Okay? But it
that don't lead to collecting the money.
doesn't answer the question, where is the bank that he stole the money from?
But the bank is insolvent. That's why.
Who is insolvent? They came and told you stories. Do you know banks that cannot even publish audited accounts today?
But you have not presented any evidence that says that the bank was solvent.
Did they provide you with evidence apart from what they wrote?
Yes,
They wrote a story and you are believing their story.
disputing it.
So who is supposed to prove it?
Sorry, you are disputing the claim that
Because they haven't provided anything.
And you have not provided any claim to me, evidence to me that the bank is
that just as they are keeping their records, I have my records. Did the Bank of Ghana show you when they did their internal quality assessment?
Quality
assessment.
Yes.
They showed you the negative figures. Did they show you the negative figures?
I didn't see any report on that.
Of course. So they told you what they wanted to tell you, just like today.
But I've not seen.
Just like they brought Boulder's report and told you something, and today they are doing something else.
I've heard Kofi Amoabin say that the solvency issues they raised were real.
We are not disputing that.
Again, even in the case of William Atu-Essien's, what they call it, Capital Bank, they have not disputed the solvency issues.
So all the banks were insolvent?
No, it's not all of them. I'm talking about these two that we are dealing with now.
And I'm saying
because
that
Capital Bank is what they have sent people to court.
Two, you and I have spent over 2 billion on these two. And I'm saying that with 2 billion, we should be having people going to work every day. With this 2 billion, I should be able to walk into Capital Bank and do a transaction today. With this 2 billion, we should be able to recover the money from Essien if it is true to a living bank. Today,
we're in court on that, right?
On what?
We are trying to recover money from him.
For what? For a dead bank?
The civil
for case. A dead bank? You recover money for the one whose monies were stolen. Who is he? Where is that person? That person is gone. He's dead. You have actually appointed an undertaker. Do you know a receiver is an undertaker?
Yeah.
Who just buries a dead body. So you have actually appointed an undertaker to bury this bank. So when you now collect the money, of what you say, what if you fail? And the guy also go to court and you fail? You and I will now have to cough money to give to this man because of the misconduct of certain selfish people. And there are a lot of judgment debts that are awaiting this country from these banks.
Lawyer, what could he have done differently?
Who?
What could the government of this republic have done differently
in terms
going
of
to court? In
terms of the charges that
yes, in terms of having criminal prosecution of the people, which is what many demanded in this country.
You can't demand what does it exist.
But the people, okay, please,
yes.
The situation. The Honorable Adongo supposed to take your time. I will not allow you to take your time. Please proceed and tell me what
they find themselves in a very difficult position, situation. And as we've said time and again, the law is inadequate for the problems we have. So
we couldn't have prosecuted them. Is that what you're saying?
Yes.
Criminally.
Yes, because the accusations that were leveled against them, in the report, do not constitute stealing. But in any case, what I'm saying is that if something happened, then we should include more of the offenses involving dishonesty, like defrauding, by false pretenses, fraud itself, and all that. But to say stealing is a bit weird. No. But for the Criminal Offences Act, which is the law for crimes anyway, nothing could have happened to these guys. They would have just walked scot-free.
The question I'm asking, are you saying that they should add more charges to it, or they shouldn't have charged them under the current, what they call it, laws that they've charged them? That's what I wanted to be clear on.
I'm saying that they cannot charge them under the Banking Act because there are no crimes there.
But they were not charged under the Banking Act.
That should have been the natural course of action to take.
I get you, but they didn't do so.
Yes.
My point here, and I'll ask you.
So now we have what we can refer to as trumped up charges. These charges, yes, these charges are being forced on them because some political situation demands action. That is it. And also because he granted this interview, it's so clear. But for the interview and the agitation that came as a result of the interview, and no action would have been taken because government does not find the specific law, to charge them, under because of these allegations.
Because I'm wrapping up this conversation.
Yes.
I want to be clear on this. You're saying that they shouldn't have been charged under the current laws that they were charged under.
That's not what I'm saying. I'm saying that there is no law that criminalizes what the Borders report is talking about. There is no law. So we are, as Honorable is saying, we are crucifying these guys, and yet we know that no action can be taken against them.
So we knew that they couldn't be prosecuted.
Yes.
And yet we found laws to prosecute them.
If I can come in, you see, I want to differ a little bit.
Yes.
It is not.
You disagree with him?
Yeah, I want to differ a little bit. You see, it is not to suggest that if you commit fraud or conflict of interest, as a director, shareholder, or employee,
it can't be prosecuted. It can't be prosecuted.
Good.
Yes.
They don't have that. If they had that, they won't be struggling with stealing.
Stealing, yes.
So the guys have not committed any fraud. As far as I am aware, you have not.
But who alleged fraud?
The one who alleged fraud is the one who is in court.
Yes, I'm saying that. When did they allege the fraud?
No, the facts that have
been put out.
You know, it suggests that
there were fraudulent misrepresentations and all of that, or that they went there and saw that there were conflict of interest situations, and you go to court, still on the basis of the original act, you can get a prosecution, and you need a thorough forensic audit to do it, not a fund management company.
For example,
advisors to go and
for example,
let me make this quickly. Honorable, give me
for example, one of the allegations, stated in the Borders report was that a letter was written to the Bank of Ghana, alleging some level of capital, which was not true. So why can't we just pick out that single letter that was written to the Bank of Ghana based on false representations and mount a prosecution on that? What is happening to that letter? That letter that misrepresented the capital status of the bank at the time the license was being acquired. Where is it?
But
and what are we doing about it? Because that's a major
government
issue.
Lawyers mostly would evaluate all the evidence. And
no, but it's clear.
They can win in court, is it not it?
No, but this is a record you have.
Yes.
It's a record you have. Somebody signed that letter, and you say that the figures stated in that letter were wrong figures, meaning that the Bank of Ghana was deceived into believing that the bank was ready to qualify or qualified to be given the universal license. And now you find that it was false. You don't just let that letter pass.
You agree, disagree?
You see, the issue about that letter, we need to understand that.
Maybe I have to go quickly.
We need to understand that Capital Bank wasn't a greenfield bank. It was converted from a savings and loans into a universal bank.
That's true.
In the process, there are assets on your books that can get impaired even after you have submitted them. Okay, so if I submit that, I have done my work, my capital is about 200 million. And over a period when you are doing the investigation, you come to see that part of that has been impaired. It is not that I consciously came to lie to you, but that because it was a going concern and the capital was based on assets that were already in existence, those assets can be impaired. And so when you now realize that they didn't really come to fraudulently lie to you, but it is that the assets that they gave to you, some got impaired.
Yeah.
How can you go to court and say that? And it was the same case with Bed Bank.
Gentlemen.
Bed Bank had impaired assets at some point.
I get your point.
And you got up and said that because of that you have taken
unfortunately, I've run out of time. Forgive me.
Yes.
And thank you so much. The lawyer, Elikli Magbema, and the Honorable Member of the Finance Committee of Parliament. Folks, that's where we end today's edition of UPfront. Many thanks for joining us.